just have to write this in your materials.
It's not even exactly an employee benefits issue, but we thought we would raise it because it is important to those in HR. In March, a law was passed called the Restore Employment Act. I'm sorry, Hiring Incentive to Restore Employment Act, HIRE, HIRE Act. And it's essentially a tax credit. It is a tax credit to any employer who employs someone who was previously unemployed. And it is an exemption from the employer Social Security contribution of the 6.2% that you would pay on your payroll for each employee, up to $1,000 for that employee. There is a form W11 that goes along with this that you have to have the employee sign, basically stating that they were unemployed prior to being hired, and that basically just means they were working fewer than 40 hours a week, according to the IRS guidance. And so, and this goes through the end of this year, currently. So this could be a nice tax savings for those who are hiring or have hired. Yes?
What if all of your employees work less than 40 hours?
Well, I think it has to be someone who was hired, let's see, after February 3rd and before January 1 of 2011.
So if when they're retained by you, they're hired by you, and they work less than 40 hours a week, they continue to maintain the eligibility?
I think they have to be hired on a full-time basis. I don't know that that necessarily means 40 hours a week. It may be a 30-hour-a-week rule. I don't recall, but the person, it is to encourage employers to hire people that were out of a job before, but it doesn't necessarily mean someone who lost their job before too. It could be someone you're hiring who maybe was in school beforehand. And I want to just mention too that W11 form, it's a brand new form that's available, just came out in April from the IRS. It's just an affidavit for the employee to sign and give to the employer, so that the employer, and it's under penalty of perjury, so the employee is basically certifying that they were unemployed and therefore that the employer would qualify for this tax benefit. The employer does not have to use that particular form, the W11 form. So it's out there for you to use, but if the employee gives you the same kind of an affidavit, sworn statement in some other fashion, that would be fine too. Question here.
I think too, it also is for new position or for if you're replacing a position, that person who left the company actually voluntarily left your employment.
Yeah, did everyone hear the point there? That's quite right. That if you're just replacing people, you're not going to get the credit for the new hire. And if you're just, if you, it's really trying to encourage, brand new hires, not just the normal turnover from one person to the next.
Although in one of the Q&As, on the website, it says if an employee laid off in 2009 has been receiving COBRA premium assistance, for which the employer has been taking COBRA premium assistance credit, and the employer rehires the employee, can the employer take the payroll tax exemption under the HIRE Act for wages paid to the employee? Yes, if the employee is a qualified employee. So it can be someone that you had previously laid off that you're bringing back, as long as you're bringing them back, after February 3rd, 2010.
So if it was somebody if you were a seasonal employer, you'd be eligible.
Yeah.
I think so.
Yeah. The question was, if you're a seasonal employer, would you be eligible? And yes.